In the manufactured housing and apartment industry, a tenant who owes $9,000 in back rent can suddenly claim your property had bed bugs for months, unraveling your eviction case or at least complicating it instantly. These last-minute defense tactics have cost countless property owners thousands in lost revenue and extended legal battles that drain resources over time. Let's face it, no matter how thorough the screening process is, every manufactured housing community and apartment complex eventually encounters residents who can't or won't fulfill their lease commitments. Life happens, circumstances change, and suddenly that reliable tenant is months behind on payments. Here are 3 critical strategies specifically for manufactured housing and apartment owners to protect their properties and bottom line when heading to court. Some landlords attempt to pursue tenancy termination cases instead of money judgment cases, believing this strategy prevents tenants from arguing about maintenance issues. While it's true that in some states, termination cases don't permit tenants to argue reasons they should stay due to maintenance problems, this approach comes with significant challenges. When pursuing a termination case, judges will scrutinize whether a tenant has an active lease in place. If the lease hasn't expired, landlords need to justify why they're terminating the lease. Terminations can't be arbitrary. There has to be a specific rule violation. Consistent non-payments can be grounds for termination, but judges usually convert those cases back to money judgment cases, telling tenants they can stay if they can pay. Tenancy termination cases work best when dealing with expired leases that have converted to month-to-month agreements. Otherwise, pursuing money judgments with these next key strategies is typically more effective. One of the biggest mistakes manufactured housing and apartment managers make is waiting too long to address non-payment issues from leaseholders. In a recent case, a resident accumulated $9,000 in back rent, potentially 6 months of lost income. Unlike condominium associations that have different collection procedures through assessments, rental properties require swift action. When manufactured housing and apartment managers delay taking action on lease violations, they're not just losing the current revenue. They're giving tenants time to build defense strategies. The longer someone lives with an issue, the more credible their claim becomes that the property had problems all along. Instead, establish clear protocols for lease enforcement that trigger legal action after a specific time frame. Let's take an arbitrary number, 15 days, for instance, after a missed payment. Whatever works for your situation. The consistent approach protects both the rental property itself and your cash flow. Lots of manufactured housing and apartment owners rely exclusively on their attorneys to handle tenant eviction proceedings in court, but this can be a costly mistake. Attorneys know landlord-tenant law, but property managers know the specifics of each rental situation. Unlike condominium associations that typically handle collections through assessment liens, manufactured housing communities and apartment complexes need to navigate landlord-tenant court. When a tenant makes unexpected claims in housing court, like suddenly reporting maintenance issues they never mentioned before, a knowledgeable property manager can immediately go to their database. They should be carrying their laptop computer with them, and they can verify or refute the statements of the tenant that they're making to the judge with specific knowledge about the property history. Attorneys can't do that. Having both an attorney and property manager present shows the court that the proceedings are being taken seriously by the landlord or property owner, and it provides immediate access to relevant information that could make or break the eviction case. Before we go on to this next point, I want to just reflect on something. You should be asking yourself this question. If I just send my attorney to court, can't I just give them all the notes I have on the tenant? You can do that. Your success rate is going to be consistently lower than someone who shows up with a property manager and the attorney present. Why is that? Because tenants come with curveballs. You don't know what's coming until you actually show up. You might think a tenant's coming straight at you, but that haymaker is probably coming from the left or the right. You have to be prepared. The only people who can really defend those kinds of situations effectively are the people who live it, who have worked with that tenant. Attorneys, remember, they handle multiple clients. They cannot be expected to have the same level of proficiency as the individual property owner in handling those curveball, haymaker, call it what you will, issues. The red herrings that the tenants are going to come with. And remember, the more behind a tenant is on rent, the more likely it's going to be that those red herrings are going to come into play in court. If you are not ready for them, a couple things can happen. First, you can lose. Not likely. The second is there can be a delay in the hearing. We have to get the property manager here. Your Honor, I, the attorney representing the plaintiff, don't know how to handle this issue. The property manager is the one. Judge says, let's just schedule another hearing a week, 2 weeks, 3 weeks from now. We'll have the property manager here and they'll talk to that. Boom, you just cost yourself 3 weeks. And what did you do? Not only did you cost yourself 3 weeks in rent, but you allowed the tenant more time to build their case even more, to get an attorney, to file gosh knows what at the state or federal level against you. I've seen these cases just balloon and mushroom into horrendously difficult situations that could have been handled had the property manager been there. We make a point to recommend to our clients that that is a strong, strong position to take. If you have an eviction case, show up, get it done, get the W, move on. So in housing court, for manufactured home communities and apartment complexes, documentation isn't just important, it's everything. We spent just the last minute or so talking about how to win in court by showing up. Of course, that's in my world, that's a given. You show up, obviously. But you've got to show up with evidence. So if you show up and you have no photos, your notes are shoddy, audio recordings aren't there, you haven't saved emails, okay? Shame on you. Now it's your word against theirs. You can increase your odds of success by keeping good digital records. And unlike condominium association cases that follow different legal processes, tenant eviction cases require comprehensive documentation of the landlord-tenant relationship. Manufactured housing and apartment managers should implement digital record-keeping systems specific to rental properties that capture dated records of all tenant communications, maintenance requests, timestamps, and resolution details, payment histories with specific dates and amounts, and vendor receipts for all property work. When a tenant claims they reported an issue months ago, the ability to instantly access complete records that show otherwise can immediately strengthen the property owner's position with the judge in housing court. Housing courts across the country are increasingly embracing digital evidence and modernizing their procedures. Recent studies from Princeton University researchers have found that tenants with legal representation are significantly less likely to face eviction warrants or possessory judgments. That trend has accelerated as courts adopt digital record systems that make documented maintenance histories and communication logs more influential in court decisions. Property managers who leverage comprehensive digital documentation systems can gain a distinct advantage in the evolving landscape that we're talking about here. Research from the Lawyers Committee for Better Housing shows that even cases that don't result in eviction orders can still damage a tenant's rental prospects through public records. This highlights the importance of having clear, accessible digital records that demonstrate your property has been professionally managed and maintained. Remember, housing courts often favor tenants in apartment and manufactured housing cases, and judges take eviction cases very seriously. Success in these landlord-tenant disputes depends on acting quickly when problems arise, bringing knowledgeable staff to hearings, maintaining meticulous records, and adopting to the digital evolution of court procedures. Manufactured housing and apartment owners should review their current collection processes this week. Consider how quickly does the team address lease violations and non-payment? Are communication protocols in place specifically for tenants? Is the documentation systems for tenant interactions accessible, digital, and complete? Have you integrated digital record keeping that will stand up to scrutiny in today's modernized housing courts. Addressing these questions now could save thousands in lost revenue later. I want to close by reminding everybody who listened here that condominium associations do follow a completely different collection procedure through assessment liens rather than landlord-tenant court, making these strategies we talked about in this video specific to rental property owners. If you found this perspective valuable, we invite you to connect with us. Facebook viewers, like our page and follow us for regular updates. Feel free to message us directly with your questions or community challenges. Instagram viewers, hit follow and feel free to DM us with your questions or community challenges. YouTube viewers, subscribe to our channel and check out the video description for helpful links. Visit our website to discover our thought leadership content, books, and resources that can transform your community management approach. Whether you're dealing with the challenges we discussed today or other community issues, we're here to help. Thanks for watching, and we'll see you in the next video.